type of company that can be incorporated under the Company Act 2016, namely company limited by share, consist of private and public company, company limited by guarantee, and unlimited company. Firstly, the company limited by share is the shareholders or members are legally responsible for the debt of the company to the extent of any unpaid amount of the share in the company. A company limited by share can either be a private company or public company. Under this, private limited company in Bahasa Malaysia is called a sendirian berhad. If you are a foreigner, this is the only type of company that you can incorporate in Malaysia. As the name suggests, the share of such company are privately issued to individual and or corporate bodies, and the minimum number of the shareholder required in a private limited company is 1. The next type of company limited by share is public limited company that is called berhad. Public limited company may not be listed on the stock exchange, but are usually listed to obtain the full benefit of being a public company. There is no cap to the maximum number of shareholders in a public limited company. The second type is the company limited by guarantee. As mentioned above, a CLBG is a public company by default has the term berhad. CLBG are widely used for non-profit company such as charities, community project, club, society, and other similar bodies. No profit or dividend are distributed to the member of the company. Lastly, an unlimited company, as the name suggests, means that limited liability does not apply to its member or shareholder. As such, its member or shareholder will be personally responsible for the full extent of any losses if it occurs. Now, I will be discussed on the characteristic of a company. There are 6 main characteristics of a company. Firstly, incorporated association. It means that a company must be incorporated or registered under the Companies Act. Minimum number of members required for the purpose is different in the case of public and a private company. Next, company is an artificial person, does not possess the body of a natural being. It exists only in contemplation of law. Being an artificial person, it has to depend upon a natural person, namely the director, officer, shareholder, etc., for getting into various works done. Regarding the separate property, a shareholder is not the part owner of the company or its property. He is only given certain rights by law, for example, to vote or attend meeting. In the case of Makara vs. Norton Assurance Company, it stated that no shareholder has any right to any item of property owned by the company, for he has no legal or equitable interest therein. Then, a shareholder can transfer his share to any person without the consent of other member. And also, the effect of incorporation also include perpetual succession, being distinct from the members, the debts, insolvency or retirement of its member leave the company unaffected. Member may come and go out, but the company can go forever. Lastly, regarding the common seal, a company may, under its common seal, if any through the general or special power of attorney power, any person to execute the deeds on its behalf in any place either in or outside Malaysia, due to it does not have the mind on its own or physical capability.
Good day everyone. So today I'll be presenting the registration of a company. Registering a business is important as according to the case of Skyville Development Sendirian Berhad versus Sky Holdings Berhad, it states that it guarantees that companies comply with the law and we are also able to recognize who the true legal owner is. So in order to be able to register a business, there are a few requirements that needs to be fulfilled according to the Suruhanjaya Syarikat Malaysia, which is also known as SSM. So to begin with, under the provision of Section 5 of the Registration of Business Act 1956, a business must be registered no later than 30 days from the starting date of the business. Further, the owner or business partner must be a permanent resident of Malaysia or a citizen of Malaysia, and they should be 18 years old or above. And the place of business must be within Malaysia. So according to Section 15 of the Companies Act 2016, once all the requirements are fulfilled and satisfied by the registrar, then the registrar will register the business. So in order to register a business, the owner can go directly to the counter or they can also apply online through the website called SBiz Online. So that is all from me and I'll pass it to the next presenter.
Good day, madam. Myself, Dhasheera, and I will now be continuing with the presentation of registration of a company's name. Section 25, subsection 1 of the Companies Act explains regarding the name of the company, where it mentions that the name of company shall end with Berhad if it's a public company, Sendirian Berhad if it's a private company, or only Sendirian if it's an unlimited company. Moving on to the availability of the company's name, which is governed by Section 26 of the Companies Act. Section 26 subsection 1 explains that the name of a company is available if it is not undesirable or unacceptable, identical to an existing company, corporation or business, identical to a name reserved or name that the minister has directed the registrar not to accept. Section 26 subsection 2 on the other hand mentions that the registrar has the sole power to determine whether or not the name is undesirable, unacceptable or identical. Section 26 subsection 3 on the other hand explains that the registrar should publish in the Gazette any name that the minister had directed not to accept. The confirmation of availability and reservation of a company's name is governed by Section 27 of the Companies Act. According to Section 27 subsection 1, a person shall apply to the registrar to confirm the availability of a proposed name, and the registrar, if satisfied with the name, shall confirm the availability of such name according to Section 27 subsection 2. In cases where the registrar rejected the proposal of such name, the aggrieved party may appeal to the minister within 30 days of the rejection, and the minister's decision shall be final according to Section 27 subsection 3. Moving on to the reservation of company's name. According to Section 27 subsection 4 of the Companies Act, the application for the reservation of the company's name must be done prior to its incorporation, not after the company is incorporated. And the registrar shall reserve the proposed name for 30 days when it can't be refused on any ground, and also upon receiving payment of prescribed fee according to Section 27 subsection 5. And lastly, the confirmation of the availability or reservation of the name does not by itself means that the company is registered by that name, and this was mentioned in Section 27 subsection 6. A landmark case to illustrate the registration of company's name is the case of North Cheshire and Manchester Company Limited versus Manchester Brewery Company. In this case, Manchester Brewery has been established for some years, and they were doing a large business in Manchester. North Cheshire Brewery, on the other hand, had a brewery in Macclesfield and some businesses in Manchester. One day, the North Cheshire Brewery was sold to the appellant, and the appellant incorporated a company with the name of North Cheshire and Manchester Brewery. The respondent then sought an injunction in order to prevent the appellant from using that name, because it might imply that the two businesses were connected. It was held the injunction granted, even though the appellant did not choose the name to take advantage of it, but the two names were so similar that any person would conclude that the two businesses were connected. So the injunction was granted on this basis.
Good day, Miss. My name is Sathiyashri Veerapathiran, and I will be presenting about application for incorporation. Section 14, Clause 1 clearly states that a person who intends to form a company or establish a company, they must apply for incorporation to the registrar, and the company must only be established for lawful purposes as stated in Clause 2. Thus, the applicant must prepare documents such as the name of the proposed company, status of the company, and whatnot, as stated under Section 14, Clause 3. Moving on, it must also be accompanied by a statement from each promoter and also the directors to confirm that they have consented to become the promoter and also the directors of the said company. It also ensures that the promoters or the directors, they are not disqualified under these. Moving on, once the registrar is satisfied that the applicant has complied with all the requirements that has been mentioned earlier and he has paid the fees, the registrar will automatically register the particulars of the company into the register and assign the company with a registration number and issue a notice of registration. However, it must be taken note that the registrar also has the power to refuse to register according to Section 16. This was illustrated in the case of R versus Registrar of Joint Stock Companies, where the registrar refused to register the company just because it is unlawful. Further, Section 17 states that upon the registration of the company and payment of prescribed fees, the registrar will issue a certificate of incorporation. The process for application for incorporation has been summarized in this slide, where firstly, the applicant must prepare documents as stated under Section 14 Clause 3 of the Companies Act. Second, they must pay registration fees according to the type of company that they intend to establish. Third, the registrar must be satisfied with the applicant. Fourth, the registrar will issue a certificate of incorporation after the registration and payment is made. That is all from me. Thank you.
The first relevant section is Section 46 of the Companies Act 2016. It states about the requirement of a registered office. Section 46 subsection 1 states that every company is required to have a registered office in Malaysia to make communication and notice easier and simpler. Secondly, the registered office needs to be open so that the public can enter into the office during the ordinary hour, which is the usual time of the work. Thirdly, the registrar shall be notified of any change in the address of the registered office within the 40 days of such change. Also, the company and every officer who contravene these sections commits an offence and shall on conviction be liable to a fine not exceeding 50,000 ringgit. A case to explain is Samat Company Sdn Bhd against the Nico Products Sdn Bhd. In this case, the defendant company changed the registered address and informed the registrar that it has changed registered address. The defendant sued under the Companies Act. However, this registered address was not entered into the register record for many months. The plaintiff served writ on old registered address. The plaintiff doesn't know that he has changed the registered address. It was held that the relevant date was the date of the lodgement, the day which the defendant informed the change of address. Therefore, the service was invalid. Section 61 states that it is up to the company whether to have a common seal or not. Secondly, if the company desires to have a common seal, then on the seal there need to be the company's name and registration number being engraved onto it in legible romanized characters. Thirdly, if a company has a common seal without complying to the Section 61 subsection 2, then they will be considered to have committed an offence. The person that will be liable for committing the offence will be the person that uses or authorizes the use of such a seal, and he will be personally liable to a fine that is not more than 50,000. Then Section 64, which states that a company contract is required by the company in which the contract can be formed by a company, a representative of a company acting under its authority, either express or implied or orally by such representative. Secondly, any formalities required by law in the case of a contract made by an individual shall apply unless the contract otherwise requires to a contract made by the or on behalf of a company.
As a conclusion, the biggest benefit of a corporation offer over business structure is liability protection in the form of separate legal entity according to Company Act 2016. Shareholders do not risk losing personal asset because of company debts, because corporations are considered separate legal entity from the people who own them. Owner of a partnership and sole proprietor on the other hand are held responsible for all company debts and legal responsibilities and are subject to losing personal asset if the company goes bankrupt or is caught up in costly legal situation. However, deciding on the most suitable business entity to register gives you an upper hand in getting started with business legally in Malaysia. Bear in mind, even though you may enjoy more financial security when running your business as a company, all companies incorporated are required to fill mandatory obligations such as getting company secretary, lodging annual return and filing taxes. Hence, it is crucial to weigh the pros and cons of each process entity in advance to make the most out of the process. Thank you. That's all from our group.